Thank you. In section 3 of the submission that you gave us at the beginning of the week there, section 3 is on the provision of the refund guarantee. In section 3.6, you stated that CMAL had no awareness or involvement in any of the exchanges, and that was the exchanges referred to between MSPs, etc., on the non-provision of the refund guarantee from FML. Can you tell me when it was you actually found out that FML weren't given the builder's refund guarantee, and at that point why you didn't go back to the tendering process?
We became aware that they could not provide a CBC guarantee on the 21st of August. We were not aware until around about the 25th of September that they were also having problems in producing a guarantee from a bank or an insurance company, and they gave their final position in relation to that on the 7th of October, by which time they were already preferred bidder and we had stood down the other bidders.
Right, so the point that you found out that they weren't going to give you the builder's refund guarantee, and that was part of the tendering process, why did you not cancel the contract at that point and go back to the tendering process, which in the communication that you've sent through or that we've seen seemed to be your preferred choice? That
was indeed the preferred option.
So why did it not happen?
Because the Minister authorised us to proceed.
What Minister was it?
My understanding is that it was the Transport Minister, but we are not cited on the conversations that Transport Scotland had with the Minister. What we have is a letter authorising us to proceed toward the contract by the Scottish Ministers as shareholder, as sole shareholder of CMAL, and that is contained in the letter which John Nichols wrote at the time that the contract was awarded.
So why did you not get a copy of the paperwork? It does actually say in the paperwork somewhere and here that you did ask for a letter of comfort. So it's got in, the Chair requested that Transport Scotland provide CMAL with a letter of comfort if required. John Nicholl agreed that a letter of comfort would be provided to CMAL. But there doesn't seem to be a lot of communication or evidence to show that the letter of comfort was put in.
We do have the letter of comfort. It's the letter that John Nichols wrote at the time of the award of the contract.
And you were happy to accept that at the time?
The letter from John Nichols said that ministers had approved the contents of that letter, had read and approved the contents of the letter. And we relied on that. That letter did two things. So it gave a shareholder authorisation under the Articles of Association of CMAL, which was an instruction to proceed by the Minister. It also gave CMAL an unconditional financial undertaking, unlimited in time and amount, to protect the solvency of CMAL if there was a problem with the contract. Now, I was heavily involved in the drafting of that letter. I'm a lawyer by training. So that letter was agreed. Some of it was drafted by me. And it was also reviewed by Scottish Government Legal Department and approved by them.
So at the time, were you happy to go forward with the contract, or did you feel that you were being forced into it?
Our preference was to retender. We were authorised by our shareholder to proceed. That was an instruction to proceed.
There's another. Just asking this bit in section 6.9, CMAL were told that they should not seek a ministerial direction by the ministers in relation to contract award to the vessels to FML. However, the board were concerned that the contracts in these circumstances and said to seek a letter from the ministers holding CMAL harmless in the event that the contracts encountered the financial and technical issues identified in the risks paper. I'm still going back to, I don't understand why at that point you seemed very, very concerned. I still don't understand why CMAL did not just go in and cancel the contract.
Because we were authorised to proceed by the Minister. We were given a direct instruction in the letter from John Nichols as our shareholder. If your shareholder instructs you to do something,
That's what you do.
You do.
So basically you were told to go in. It's just, some
We
of
were
the,
authorised to enter into the contract,
and
yes.
some of the further evidence that we got when we were speaking to Roy Brannan, he's basically said that Transport Scotland did not have a role in the contract. It was between CMAL as the buyer and FML as the builder. CMAL had to satisfy itself that it was able to enter into that contract and resolve whatever issues were apparent. So Roy Brannan is basically saying that it wasn't to do with ministers, it wasn't to do with Transport Scotland. The decision was with CMAL.
And I would disagree with that.
So you disagree with that? Okay.
I just, on the ministerial direction point, if I may, we were told not to ask for a ministerial direction, that's true, but I wasn't entirely sure in any event that ministerial direction was competent in relation to the board of an NDPB, and I think David Middleton perhaps alludes to that in his written evidence to the committee. But what clearly was competent was a shareholder authorisation in relation to the shareholders' reserve powers under the Articles of Association, and that protects the directors in terms of their fiduciary duties. So that was what we sought. It was a shareholder authorisation by the Scottish ministers. And that is contained in the letter from John Nichols.
Okay, great. I might come back to more questions.